Hi, my name is Larry Newman. I'm a criminal defense attorney. I'm located in Ithaca, New York. I do two primary things. I do things that involve cars and things that involve drugs. My specialty area is DWI defense, and today I'd like to talk to you about DWI refusal cases. The DWI refusal case is where you refuse the chemical test back at the police station or back at the trooper barracks. This is not a refusal of the roadside test or the one that's done by the police out in the field. That is called an alkosensor test. That test is not calibrated, that test is not reliable, and that test out in the field is therefore inadmissible in all New York State courts. But the test back at the police station is called a chemical test, and that test is admissible against you in New York State courts. If you refuse that test, the chemical test, back at the station, then your case is a DWI refusal case. And they're only going to charge you with one DWI. They're going to charge you with common law DWI 1192 subsection 3. Common law DWI, they need to prove inability to operate an automobile as a reasonably prudent driver. Inability mentally and physically to safely operate a car. Now, there's certain things that are positive about the refusal case and there's certain things that are negative about the refusal case. Number one, since there's only one charge, their whole case, the government's case, the prosecutor's case, is going to be totally based upon the observations and the testing of the person that stopped the car or the investigating officer or officers. So it's an opinion case just based upon that police officer's opinion of whether you were intoxicated. Now, what's the difference between intoxication and impairment is one really of degree. And that to be determined by somebody to say how well you walk, talk, balance, and everything else. Are you able to drive an automobile? It's capability there. Number two thing about the refusal case is there's going to be a Department of Motor Vehicles administrative refusal hearing. This is an opportunity for your defense attorney to cross-examine the police officer out of the presence of the prosecutor in front of an administrative law judge concerning probable cause for the stop, probable cause for the arrest, and to talk about the refusal warnings and whether your refusal was truly persistent. But this is an opportunity for pre-trial discovery. The bad things about the refusal case are, number one, you have no license. Generally, you'll have no license to drive, not even a conditional license to drive while your case is pending. Number two negative about the refusal case is the government can request and will usually get from the court, from the judge, a jury instruction, a specific instruction from the judge to the jury stating that the reason for your refusal is because you're conscious of your own guilt. It's called a consciousness of guilt charge. Now, I believe as a criminal defense attorney that handles DWI cases that there's two primary reasons people refuse the breath test. Number one, they want to exert their Fifth Amendment right not to self-incriminate. Or number two, they were confused and they weren't sure whether they should take the test or not. But the prosecution is allowed to request this charge and it can be damning in front of a jury. Before you go into your court hearings on your DWI refusal case or your DMV refusal hearing, contact an attorney. Talk to an attorney. You can give me a call at 607-229-5184, or you go to my website and blog at www.ithaca.com. Be more than happy to help you with your situation. Thank you.